Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's discussion. On this week's discussion, our topic is the medical decision-making system of substantial medical evidence. And if you've been a qualified medical evaluator for any length of time, you certainly heard the phrase of substantial medical evidence. And you may have a greater or lesser degree of understanding of what the concept of substantial medical evidence is and how substantial medical evidence relates to the way in which you fashion the opinions and conclusions in your reports. And today's discussion is going to solidify your understanding of this concept, this difficult concept. And it's going to transform your report writing process from here on out. And not only is it going to transform your report writing process, it's going to transform your thinking process and the process with which you use to arrive at your difficult medical decisions. So in all actuality, substantial medical evidence is actually a medical decision-making system. And you can use this system in your very next evaluation to incrementally improve the content and quality of your report. If you can adopt this concept and adapt this concept to your own reporting, your reputation as a qualified medical evaluator will expand far and wide as the parties realize that you are a competent and qualified medical evaluator who can write reports in such a way that disputed issues can be quickly and easily resolved within the system, because the system relies on reports from us as qualified medical evaluators, and the system can use reports from us as qualified medical evaluators when those reports qualify, when they escalate and elevate to the high level of what's referred to in the system as substantial medical evidence. On the other hand, reports that do not qualify as substantial medical evidence are worthless in the system. They're wasted reports, they're wasted cycles of action, they're wasted money, and they cause unnecessary delays and costs in the system because they have no capacity. They have no capacity to resolve disputed issues. The resolution of disputed issues in our system relies, depends, and hinges and requires that our opinions reach a certain level, and that level is the level of substantial medical evidence. So in today's discussion, I want to share with you some definitions of substantial medical evidence, and once we have fixed in our mind the tenets and the important principles and the important components of what actually constitutes substantial medical evidence, then we're going to build on that. We're going to build on that concept, on that foundation. And I'm going to show you how to install substantial medical evidence opinions into your reporting. And I'm going to show you how to think, and how to fashion your opinions and conclusions using this new thinking method, such that the opinions and conclusions that you offer in your report in those difficult sections of your report over which you routinely struggle, these sections of your report are now going to become effortless because you'll have a system for bringing you normally and naturally to the correct and proper conclusion on every single issue. And if you can adapt this system into your reporting, you will always be correct on every single issue, and you'll probably never make another mistake as a qualified medical evaluator. So I have a fascinating discussion for you today, one which I'm certain has the capacity to catapult your reputation as one of the top-notch qualified medical evaluators in the system, and one upon whom the system can rely to actually resolve disputed issues. So I'm excited to bring this presentation to you today. You can find this presentation nowhere else. And so with that as our introduction, let's begin today's discussion entitled The Medical Decision-Making System of Substantial Medical Evidence. Okay, so let's begin today's discussion entitled The Medical Decision-Making System of Substantial Medical Evidence. Now, The need for reporting that qualifies as substantial medical evidence has never been greater than it is right now. And the scrutiny on our reports to confirm that our reports do constitute substantial medical evidence has never been greater than it is right now. And the increased scrutiny on our reports stems from a recent 2019 state auditor's report. And I've included this state auditor's report as a copy of your handout materials to accompany today's discussion. So in late 2019, it was actually in November 2019, so not that long ago, the state auditor conducted a review of the Division of Workers' Compensation over many different aspects. And one of the aspects that they investigated was the content and quality and usability of qualified medical evaluators' reports. When we talk about quality and usability of reports, those terms refer to the capacity for the report to actually resolve disputed issues in the system. It refers to the ability of the report to allow the case to move forward, either onto its next phase or even all the way onto its resolution. And the state auditor did a review of many reports and many of the procedures within the Division of Workers' Compensation. And they found that 85% of reports are substandard in one or more ways. Now, when you think about all of the ways in which reports can fail to rise up to a level that constitutes a high quality report, there are many ways that reports can be substandard. There can be typos in the report, there can be grammatical errors in the report, there can be formatting errors in the report. But of all the reports, of all the errors found within reports, what errors can be accepted? What errors can be forgiven? What errors can be overlooked? And what errors, on the other hand, cannot be overlooked? What errors are critical errors? And what errors in reports are non-critical errors? Well, the critical errors in the reports have to do with their ability to resolve disputed issues. In other words, typographic errors and grammatical errors can be overlooked if the report can still actually resolve the disputed issue. So it's the ability of the report to rise to the standard, where it can actually resolve disputed issues that's critical. And in order to be able to actually resolve disputed issues, the reports have to rise to the standard of what's referred to as substantial medical evidence. Now, the state auditor lamented qualified medical evaluators' low-quality reports, and she stated that the problem with low-quality reports is that low-quality reports delay injured workers' receipt of benefits, and that's terrible. Nobody wants that. That's not an effective outcome of our reporting, is to result in delays in injured workers receiving their necessary benefits to which they're entitled to by law. And perhaps even just as bad, low-quality reports can add expenses for employers that are involved in disputes, because the employers, meaning the claims administrator, meaning the insurance company, bears the burdens of all costs, and including the costs of these delays that are introduced into the system through low-quality reports. And the state auditor concluded that supplemental reports, that depositions, that replacement panels in the circumstance where the qualified medical evaluator, after attempt after attempt, can still not resolve the disputed issue with substantial medical evidence, and the parties have to resort to a replacement panel to restart the whole process over again de novo, add time and add unnecessary expense to the resolution of the claim. And neither of these are desirable outcomes. The purpose of hiring you as a qualified medical evaluator is to have you resolve the disputed issue, and preferably resolve the disputed issue the first time through with opinions and conclusions that qualify as substantial medical evidence. Now, this does not mean that if you adopt substantial medical evidence into your way of thinking and reporting, that you're never going to have a request for a supplemental report, and that you're never ever going to have to attend a deposition to clarify issues, because that would not be true. But in providing opinions and conclusions that qualify as substantial medical evidence dramatically reduces the volume of supplemental report requests, reduces the volume of depositions that are necessary to get you to provide opinions and conclusions that the parties can use. So the need for substantial medical evidence has never been greater than it has been right now at this point in time in our careers and in our history as qualified medical evaluators. So where in our reports do you think it's most necessary to raise the standard of your reporting? Well, this issue was brought up in front of the Division of Workers' Compensation, and the Division of Workers' Compensation then developed a committee, the Report Quality Committee, to address these very issues. So shortly after the 2019 State Auditor's Report came out, the Division of Workers' Compensation then proceeded to form several what they referred to as Report Quality Committees. And the Report Quality Committee set about determining what elements and what components constitute a high quality report. And I share with you as part of your handout materials today an actual check sheet from the Report Quality Committee. And this check sheet is used by the Report Quality Committee to assess your reports. Your reports, when the Division of Workers' Compensation receives a copy of your report, they pull out the check sheet and they compare your report to the components that are included on the check sheet, and they assign your report a quality score based on how closely it matches, or how many of the components your report contains from the report quality check sheet. So we won't go over the entirety of the check sheet, but I can tell you that as far as relates to report quality in terms of substantial medical evidence, your report and the check sheet has a check box next to the causation opinion. The check sheet asks, does the report contain a statement about the causation of the injury? So in order to constitute a high quality report, you must include a causation opinion within your report. And note that I've highlighted the word opinion. And you're going to see, as relates to all of these substantial medical evidence aspects of your report, all of these relate to your opinions that you offer in your report. See, substantial medical evidence doesn't relate to the factual matters of your report, such as the factual range of motion of the cervical spine or the factual circumference of the upper arm. Those are not opinions that are contained in your report. Those are simply your iterations of the facts of your findings of your physical examination. It's in the discussion sections of your report where you offer opinions that you must constitute those opinions as substantial medical evidence. One of those is the causation opinion. Another one is the permanent and stationary opinion. Does your report offer a finding of maximum medical improvement, or does it include a finding of no maximum medical improvement? Does the report contain an opinion on the permanent impairment? Is there an opinion on a finding of permanent disability? And then finally, in those cases where you provide an opinion on permanent impairment, does the report contain an apportionment opinion? In other words, is disability addressed under Labor Code 4663 and 4664. Now, for all of these opinions, the report check sheet asks, in every instance where an opinion is offered, does the physician appropriately describe how and why he or she came to their opinion? And this is where the check sheet demands that we as qualified medical evaluators qualify our causation opinion, that we qualify our permanent and stationary opinion, that we qualify our apportionment opinion, and that we qualify every opinion and every conclusion that we offer in our report as substantial medical evidence. And they give us some hint as to how to do it here. They tell us that we must describe how and why we came to our apportionment opinion, how and why we came to our particular permanent impairment opinion, etc. So as we're going to see, how and why reasoning is an important component of substantial medical evidence. So this is something that the Division of Workers' Compensation is scrutinizing each and every one of our reports to determine who among us are the best report writers, meaning the best report writers, the authors of reports that can accurately resolve disputed issues in the system, and who are those among us that need help, that need training, that need educating on qualifying their opinions and conclusions as substantial medical evidence. So let's define substantial medical evidence so that you have a good understanding of the component parts of a substantial opinion. And then after that's established, let's go into exactly how you can begin to incorporate substantial opinions into your very next report. Now, there are several important precedential cases that the courts rely on over the years, and I'm talking decades, even dating back all the way into the 60s, that the courts rely on in assessing our reports and in assessing our opinions and conclusions as substantial medical evidence. And we'll review these one by one and in order of historic significance. Going all the way back to 1968 was the Zemke case. Contains some important descriptors of substantial medical evidence, and the importance of this and the importance of sharing with you some of these historic cases is to confirm to you that the concept of substantial medical evidence is not new. The need for high quality opinions, for a certain standard of opinions, has been around ever since there have been adjudication of issues in the courts. So the Zemke is a historic case that possibly, as far as workers' compensation, may have began the entire discussion of substantial medical evidence. We have the Garza case, the West case, the Granado case, and then most recently, of course, in the granddaddy, or maybe even the grandmother, since Marlene Escobedo was female, the most important case upon which we draw our component elements of substantial medical evidence is the Escobedo case. But every one of these cases gives us a little bit of insight into what it is that the courts need from us in our reporting, such that the court can satisfy their directives in resolving cases, and the courts have a directive that cases can only be resolved upon substantial evidence. So this is a requirement of the court. This is not some penalty that's being imposed upon us just to make our lives difficult. The courts require that our opinions and conclusions qualify as substantial medical evidence such that the court can fulfill its directives in resolving cases based on substantial evidence. So let's go over each of these cases for the important principles that they illustrate. Okay, so let's take these cases one by one. Now, the Zemke case tells us that an opinion that does not disclose its underlying basis and gives a bare legal conclusion does not constitute substantial medical evidence. So the bare legal conclusion itself does not constitute substantial medical evidence. Like what? Well, say for example in your report, and I see this all the time in qualified medical evaluators' reports, in discussing apportionment, the qualified medical evaluator will say, in my opinion, 80% of the permanent impairment is due to the industrial injury and 20% is due to other factors, period. That constitutes the bare legal conclusion. And the bare legal conclusion does not disclose its underlying basis. So that conclusion on apportionment is not a conclusion that the courts can use to resolve the matter, to resolve the liability for the employer. Therefore, what do we learn from this? We learn that any apportionment, approximate percentages, your apportionment opinion, must disclose its underlying basis in order for the courts to be able to use that opinion. So the courts, for example, look at your apportionment opinion. They take your apportionment opinion and they look at it. And they look at it from a distance, not for its content, not for its numbers, 80, 20, 70, 30, whatever. They don't look at it first to see what the content of the opinion is. They look at the opinion to see if it's a substantial opinion. And they look to the opinion to see if it contains its basis, its basis for the bare legal conclusion. If the basis is present, then and only then can they look to the content of the opinion and use the contents of the opinion. But first they scrutinize the opinion to see if it's an opinion that qualifies as a substantial opinion by including the basis for the conclusion. Next came the Garza case, and the Garza case tells us that any award, any order, any decision of the board, meaning the Workers' Compensation Appeals Board, must be supported by substantial evidence in light of the entire record. The board can only use opinions and conclusions that are substantial, and according to the state auditor, more than 85% of all reports coming before the board are not substantial reports. And when they identify a report that doesn't constitute substantial medical evidence, it simply gets set aside as a report that cannot be used at the time to resolve the disputed issue, and they must then go back to the doctor, which is us as qualified medical evaluators, to develop the record, either through a supplemental report, through a deposition, or if the qualified medical evaluator is simply not able to provide substantial opinions and conclusions, then they have to start all over again and order a replacement panel, thus introducing great cost and delay into the system. The West case tells us in instructive principle that an expert opinion is no stronger than the facts upon which it is based. And we, as qualified medical evaluators, are experts, and we offer our opinions, and our opinions are no stronger than the facts upon which it is based. So this gives us another hint as to one of the components of substantial opinions and conclusions, and that is the substantial opinion and conclusion must be based on facts, and you must disclose as described in Zemke, you must disclose to the parties what are the facts upon which your opinion or conclusion is based. You know, imagine that you're at a backyard barbecue on a Saturday afternoon, and just to cite an example from popular media at the time of this recording, one person at the barbecue makes a statement about sports, and he says something like, Novak Djokovic is an ass. Or they say something like, the San Francisco 49ers suck, okay? And your friend at the backyard barbecue offers you a bare conclusion. He offers you an opinion. Well, at the backyard barbecue, you might just sort of absorb this opinion or this conclusion as a topic of conversation, and you might just roll through it and provide your response to that, either in agreement or in disagreement with that conclusion. But at the level of the courts, these opinions and these bare conclusions cannot be used unless they are supported by facts and unless the provider of the opinion discloses the facts upon which the opinion is based. Now, say for example, the Novak Djokovic issue got raised to a higher level beyond the backyard barbecue, but raised to the tennis organizations who were trying to decide whether to allow him to play tennis at various tournaments or not, and the issue had to be decided, had to be adjudicated based on facts. Someone may offer the opinion that Novak Djokovic is an ass, and then the natural reaction to that is, well, what are your facts to support your opinion that Novak Djokovic is an ass and therefore should or should not be allowed to play in tennis tournaments. And this is just an example from the popular media right now, but it illustrates how all the time in life we're familiar with back and forth conclusory opinions. Conclusory opinions are opinions that include the bare conclusion, the bare legal conclusion in the context of our reports. We're familiar with this, with these conclusory opinions. But conclusory opinions don't win the day down at the board. The board relies upon opinions that disclose their underlying basis and that are based on facts. And then Granado tells us that a mere legal conclusion does not form a basis for a finding. The San Francisco 49ers suck does not cause a conclusion that the 49ers actually suck, because the opinion is not based on any supportive facts. Okay? So these give us some idea as to the component elements of substantial opinions and conclusions, and it gives us some insight as to how to fashion those opinions within the body of our report. Let's take a look at the most recent case, the Escobedo case, to develop the exact recipe for how to formulate our opinions and conclusions. And most recently, it was the Escobedo case that clearly elaborated on the distinction, the important distinction between opinions that are merely conclusory, that offer just a bare legal conclusion, and substantial opinions, which are opinions that are based on facts and that disclose the how and why reasoning that the evaluator came to the particular opinion or conclusion. So it's the Escobedo case that shares with us and reveals our exact recipe for formulating the opinions and conclusions that we offer in our reports. And Escobedo tells us that in order to constitute substantial medical evidence, a medical opinion must first of all be predicated on reasonable medical probability. Now notice the verb. The verb is predicated. So that gives us step number one in formulating our opinions and conclusions in our reports. We predicate each opinion and conclusion that we offer in our report on reasonable medical probability. Now, what does reasonable medical probability mean? That means that the opinion and conclusion that we offer has a 51% or greater likelihood of being true. Now, this is a low threshold, only 51% requirements, not a 100% requirement. But even so, many opinions and conclusions that qualified medical evaluators don't even rise to this standard. They don't even have a 51% or greater likelihood of being correct. So when you offer your opinion and conclusion, you predicate it on reasonable medical probability, and you don't just say the words that this opinion is based on reasonable medical probability. You actually think about the opinion and confirm to yourself whether the opinion has a 51% or greater likelihood of being true and accurate and correct for your given circumstances. If it's true that it's reasonably medically probably correct, then you can proceed to further qualify your opinion and conclusion as substantial using these other ingredients in the recipe described by Escobedo. It tells us that a medical opinion is not substantial medical evidence if it's based on facts no longer germane. Facts no longer germane. So what's the opposite of facts no longer germane? The opposite of facts no longer germane is germane facts, also known as relevant facts. So like the Garza case that we reviewed in the previous slide, our opinion must be based on relevant facts, So when you offer your opinion and conclusion, you cite to the reader of the report what are the relevant facts upon which your opinion and conclusion is based. Now, note that relevant facts are different than facts. Okay, many qualified medical evaluators, in attempting to qualify their opinion as substantial medical evidence, will provide some facts will provide some facts that are factually correct. They're actually correct facts. But correct facts are not the same as relevant facts. Relevant facts are facts that are relevant to the opinion or conclusion. They're not just factual reiterations of facts from the history. They're facts that are relevant, that are germane to the opinion or conclusion. So when you offer an opinion or conclusion, say for example that 80% of the impairment is due to the industrial injury, the facts that you cite must be relevant to the conclusion. And the conclusion is that 80% is due to the industrial injury. The facts must support the 80%. So relevant facts, germane facts, are nuanced and different from facts. So just keep that in mind when it comes time to support your opinion and conclusion, and make sure that the facts that you offer are relevant to the opinion and conclusion. An opinion is not substantial medical evidence if it's based on an inadequate medical history or an inadequate examination. So make sure that your examination is adequate. Adequate for what? Adequate to support your opinion and conclusion. Now I'll give you an example of an inadequate history. I recently had one of my opinions and conclusions be called out as an insubstantial or not substantial opinion and conclusion. And I believe the party may actually have a good point, and this is a good learning principle for all of us. It was for me. And the case involved an injured female worker who, when I evaluated her, there were absolutely no medical records. There were no medical records. So the history that I obtained from the examinee came entirely from her own testimony. And in that evaluation, she told me that she had no prior history of injury to her lower back, which was the body part of concern for my evaluation. She said she had no prior history of injury to the lower back, never had any medical treatment for the lower back, and she had a pristine and perfect lower back prior to the industrial injury. So then a reevaluation came around some months later, and in the time between the initial evaluation and the reevaluation, they had obtained a deposition from the examinee. And in the deposition, the examinee admitted to a car accident approximately 2 years before the industrial injury. And in the car accident, there was some injury to the lumbar spine. Okay? So she admitted to some prior history of the lumbar spine, whereas to me in face-to-face, she denied a history of injury to the lumbar spine. So then for the reevaluation, the defense attorney pointed my attention to the deposition, wherein the examinee admitted to a car accident. And in the cover letter, the defense attorney asked me to please address the cover letter to determine if there would be any apportionment to the prior car accident. Well, in the for the reevaluation, again, there were no medical records. There were no medical records certainly related to the auto accident injury. Okay? So when I got to the face-to-face evaluation, either through omission or commission, I neglected to address the auto accident injury. My position was that the defense had failed in obtaining any necessary medical records. They were putting the burden on me in the face-to-face evaluation to unearth and discover any apportionable factors. And I either neglected to do that or I omitted to do that. And following that, I provided my opinion on the permanent impairment. And then the defense attorney deposed me. And she asked me about the car accident. She asked me if I addressed the car accident. She asked me if I followed the instructions in her cover letter, if I had read the deposition. I admitted that I had read the deposition, but I did not inquire about the history of lumbar spine injury related to the car accident. And the defense attorney concluded, perhaps rightly so, that my apportionment determination was based on an inadequate medical history, because she did indeed ask me to address it in the cover letter, and she pointed my attention to it in deposition, but I neglected to do it in the face-to-face evaluation, and that could be an example. It could be concluded that my opinion on the apportionment was based on an inadequate medical history. So that was a learning principle for me to certainly take a harder look at that type of a situation should it occur again in the future. Insubstantial or not substantial medical evidence is based on incorrect legal theories, or if your opinion and conclusion is in any way based on surmise, speculation, or conjecture, or guess. Furthermore, a medical report is not substantial medical evidence unless it sets forth the reasoning. The reasoning. This is a critical word. The reasoning behind the physician's opinion, not merely his or her conclusions. So you're going to be using the phrase many, many times throughout your report. Reasons for this conclusion include : and then you will be providing your list of reasons that will help to qualify your opinion as a substantial opinion according to the dictates of Escobedo. So let's make this practical now. Let's turn to our reports and look where in our reports where substantial opinions and conclusions are required, and then let's look at exactly how to do just that. So let's turn to our reports now and take a look at those sections of our report wherein substantial medical evidence opinions are required. And certainly you can imagine that everywhere in your report where you offer an opinion or conclusion, that opinion and conclusion must be qualified as a substantial opinion and conclusion, including the section of your report wherein you describe the examinee's limitations to activities of daily living. Those limitations must be supported by substantial medical evidence. Your causation opinion, either for or against industrial injury, AOE, COE, should be supported by substantial medical evidence. Your permanent impairment rating must be supported by substantial medical evidence, and certainly if you use an alternative impairment rating under Alvarez and Guzman, qualifying that opinion as a substantial opinion requires its own separate process and procedure to qualify that. The alternative impairment rating as a substantial, most accurate rating has its own procedure, and we'll talk about that in another program. But of course, your permanent impairment opinion, whatever it may be, must constitute substantial medical evidence. And then certainly, especially, and most importantly, probably, whatever approximate percentages you offer for your apportionment determination, those approximate percentages and your apportionment opinion must constitute substantial medical evidence. And all of these sections of your report are going to be very, very closely scrutinized by the parties to determine whether or not your opinion is an opinion upon which the case can be resolved. So let's break out of this list. Let's take a look at the causation analysis, and then let's take a look at the apportionment approximate percentages, and let's go over a process that you can use in your next report to qualify your opinion, whatever your opinion may be, as a substantial opinion upon which the case may move forward. Okay, so imagine this. Imagine you're dealing with a denied claim, and the evaluation comes to you for a compensability evaluation under Labor Code 4060, and your job is to tell us whether the symptoms that the examinee is presenting to you with are the result of an industrial injury or they are not the result of an industrial injury. In other words, is this a compensable case? Well, your opinion or conclusion basically boils down to one of two things. You're either going to provide an opinion for industrial injury or you're going to provide an opinion against industrial injury. And regardless of what your opinion is, the opinion that you offer in your report must constitute substantial medical evidence, or else the parties can't use that opinion to resolve the dispute over compensability. So in order to qualify your opinion either for or against industrial injury as a substantial opinion, You would follow the recipe as established through the Garza case, the Zemke case, the West case, the Escobedo case, and you would give the parties the conclusory portion of the opinion. You would give them the conclusory portion, and here is the conclusory portion. In my opinion, and within reasonable medical probability, so that's step number 1, is to predicate the opinion on reasonable medical probability. And then you tell us the opinion. The symptoms that Mr. Jones reports in his lower back are the result of the industrial injury of January 1st, 2020. My reasons for this conclusion include, and then here you would list the facts and the reasons and the basis and the how and why reasoning that lead you to the conclusion that the symptoms are the result of an industrial injury, and that therefore this case should be accepted as an accepted industrial injury. Now, on the other hand, if your opinion is that the symptoms that Mr. Jones reports in his lower back are not the result of any industrial injury on January 1st, reasons for this conclusion include, and then reason number 1, reason number 2, reason number 3. And here, regardless of what your opinion is, you want to have voluminous reasons, many, many reasons, and also compelling reasons. The reasons must be compelling. And of the two, voluminous reasons versus compelling reasons trump even voluminous reasons. But in general, you want to strive for compelling and voluminous reasons in support of your opinion, either for or against industrial injury. And the more compelling and the more voluminous are your reasons, the more substantial is your opinion on compensability under Labor Code 4060. And amazingly, the more reasons you can cite, the more probably true, accurate, and correct is the opinion, is the conclusion, because it's supported by voluminous and compelling reasons. So this is where substantial medical evidence becomes a medical decision-making system for you. When you're stumped on causation and you have to make a difficult decision, you can make a chart just like this. You can take a piece of paper, draw a line down the middle of the piece of paper, and that's not a very good line. You draw a line down the middle of the piece of paper and you provide your argument on one side of the paper, your argument for industrial injury. On the other side, you provide your argument against industrial injury, and you list your reasons in support of an injury, and you support your reasons against an injury, and you simply look at the list. And you simply look at the reasons, and you simply ask yourself, of these two lists of reasons, which one contains the more compelling, truthful, accurate, correct reasons? And you simply provide the opinion that has the most voluminous and the most compelling reasons. And this isn't going to be a difficult decision for you, because you'll find that one list greatly outweighs the other list. And this is how you can always, always, always be correct in your opinions and conclusions, by taking them through this particular Ben Franklin type of list. And when you finally provide an opinion, whether it's on this side of the chart or this side of the chart, if you're ever called upon that opinion, you're comfortable and confident to defend that opinion, even in deposition if it should come to that. You're comfortable and confident to defend that opinion because it's based on reasons. It's based on voluminous and compelling reasons that you feel confident to present and confident to defend. Okay? So that's an example of how you can fashion your causation argument. Let's take a look now at fashioning your apportionment approximate percentages. Now, when it comes to providing your apportionment approximate percentages, the exact recipe and formula for qualifying your opinion and conclusion as a substantial opinion comes to us from the Escobedo case. And Escobedo tells us that an opinion on the causation of the permanent impairment must be, number one, must be framed or predicated upon reasonable medical probability. Number two, it must not be speculative, based on guess, conjecture, surmise, or speculation in any way. So when you look at your reasons, when you look at your opinion or conclusion, confirm to yourself, first of all, that it's not in any way based on speculation, okay? It must be based on pertinent, relevant, and germane facts, which, as we discussed, are different from facts. It must be based on an adequate examination and history, so make sure that your examination exactly complies with the requirements of the AMA Guides 5th edition. You never want to be at deposition and be afraid that any one of the parties is going to ask you about some aspect of your physical examination, such as your range of motion measurements. Make sure that you use every single examination instrument that's described in the AMA Guides, and you perform your objective testing exactly as described in the AMA Guides. That, in my opinion, is what constitutes an adequate examination. And if I was either an applicant or a defense attorney looking to qualify a qualified medical evaluator's opinions as not substantial, I would go straight for the physical examination, because I know this is an area where many qualified medical evaluators take risky shortcuts. So don't take risky shortcuts. Take the long cuts and make sure that your examination exactly follows the procedures described in the AMA Guides so that it will qualify as an adequate exam. And then finally, it must set forth the reasoning in support of its opinions and conclusions. And I said you're going to be using the phrase, reasons for this conclusion include. You're going to be using that phrase a whole lot moving from here forward. So let's see exactly how this would look within the body of our report. Okay, so within the body of your report, this is going to look like follows. And this is just an example, but you're going to start by giving us the conclusory portion of your opinion. And you'll say, in my opinion and within reasonable medical probability, 70% of the permanent impairment is due to the January 1st, 2020 industrial injury, and 30% of the permanent impairment is due to other factors. And here comes your reasons. You tell us that the reasons for this conclusion include colon. Now notice, everything that's going to follow here becomes the substantial portion of the opinion. This here, this is the conclusory portion of the opinion, and this is as far as many qualified medical evaluators take it. They simply offer the bare legal conclusion without providing the basis. And if you terminate your argument right here at this period, the parties cannot use the opinion. The parties can only use the opinion when the opinion is qualified as a substantial opinion. So let's take a look at some of the reasons that are derived from the formula given to us by the Escobedo case. You tell us that my opinion on the above apportionment approximate percentages, which is 70% and 30%, is predicated on reasonable medical probability. Now, don't just say it. Don't just say it. Ask yourself, is it 51% or greater likelihood of true that these percentages are the true and accurate percentages? If you can't even answer that to the 51% threshold, then don't use these numbers. Change your numbers that you can be more reasonably medically probably certain of. Pertinent facts. The facts relevant to the above apportionment approximate percentage upon which I rely include, and then here you list the facts. Fact number 1, fact number 2, fact number 3. Now, when it comes to your apportionment approximate percentages, what are the facts that are relevant to the apportionment approximate percentages? These are the facts that you're going to wish you had obtained when you were in the face-to-face interview with the examinee, because when it comes time to provide your apportionment approximate percentages, you're going to need relevant facts. You're going to wish and hope that you had obtained the relevant facts to support your apportionment approximate percentage. So some facts that you're going to want some details about have to do with some of these different categories of issues. Number one, facts related to the mechanism of injury. Number two, facts related to the response to medical care. Facts related to whether or not there was any pre-existing conditions of the same body part, whether or not there was a prior industrial injury, whether there was a prior permanent disability award. These are some things that would require apportionment under Labor Code 4664, for example. If the examinee has a prior permanent disability award, you're going to want to have some facts about that injury and about the treatment related to that injury and how the case resolved and what was the condition of that body part even after the case resolved but prior to the industrial injury that you're evaluating. In other words, you need to anticipate what are the facts that you're going to need when it comes time to provide your apportionment approximate percentages. And the top qualified medical evaluators have already been down this road 100 times, and they know that when it comes time to write their apportionment argument, they'll wish they had these facts. So the top qualified medical evaluators make sure that they explore these facts in the face-to-face interview. My opinion on the approximate percentages is based on an adequate history. It's based on an adequate examination. It provides how and why reasoning, and let me explain to you how and why I came up with these approximate percentages. And here you give us how it was that you arrived at your percentages of, say, 70-30 versus 80-20. Why is it 70-30? Why isn't it 90-10? Give us the how and why reasoning that supports your numbers, And all of this argument in qualifying the opinion as substantial is becoming substantial and supportive of your numbers, Okay, so here you're supporting and explaining how and why you arrived at these numbers. And then finally, you confirm to us that the above opinion on apportionment approximate percentages is not based on guess, speculation, surmise, or conjecture. Now, doctors, you'll notice that each one of these qualifiers, if you want to call them qualifiers, reasonable medical probability, relevant facts, adequate history, adequate exam, how and why reasoning, no speculation, all of those are qualifiers. You can think of these qualifiers as like filters in a funnel. So at the top of the funnel, you pour in your apportionment approximate percentages. You pour them in, 50-50, 60-40, 70-30, 30-70. You pour in your possible percentages, all possible opinions in the top of the funnel. And only a certain number of those percentages will pass the first filter of reasonable medical probability. Some of those percentages will get clogged up at this qualifying filter. But the percentages that pass through the filter are percentages that are closer to being truthful and accurate. And then they have to pass through the next filter of qualification, which is pertinent facts. Now here, this filter is going to stop some percentages from passing through because there will be no pertinent facts to support those percentages. But a couple of the percentages will pass through this filter, and then they'll have to encounter the filter of an adequate history, and they'll have to encounter the filter of an adequate exam, and they'll have to encounter the filter of how and why reasoning, and finally they'll have to encounter the filter that, hey, this final opinion that's passed through all these filters, it better not be based on anything related to speculation, guess, conjecture, or surmise. And if it passes through the final filter, the opinion that lands on the bottom, passes through the funnel, is an opinion that has passed through all these filters. And only opinions that are true, accurate, and correct, based upon all of the facts, is the substantial opinion. And the reason it's a substantial opinion is because it's likely the true opinion. It's likely the correct determination. Why is it correct? Because it's passed through all of the filters of substantial medical evidence. So doctors, isn't that amazing? Isn't that incredible? This is how you formulate your opinions and conclusions within the body of your report, such that every opinion and conclusion that you offer is correct. This is how you become correct on every single issue. I don't know about you, but I like being right. And you can only be right when the opinions and conclusions that you offer can pass through all the qualifying filters of substantial medical evidence. So in this way, substantial medical evidence is a medical decision-making system. You only provide decisions that can successfully pass through the system. Therefore, the decision, the opinion, the conclusion that you offer is the correct opinion. And it's an irrefutable opinion. The only way your opinion or conclusion can be refuted is with new facts. Because based on the facts, based on the relevant facts that you have at your disposal at the time you offer the opinion and conclusion, the opinion and conclusion that you offered is the only correct opinion and conclusion. Because incorrect opinions and conclusions that have no substance, that are not substantial, that are conclusory only, can't pass through the qualifying filters. So in this way, you can make your difficult medical decisions in the body of your report quickly, easily, confidently, and with comfort, knowing that at any time in the future, should you be called on your opinion or conclusion, say for example in deposition, you don't have to sweat it. You don't have to worry about it, because you can defend your opinion and conclusion based upon the relevant facts that you cited within the body of your report. Now, if there are new relevant facts that come to your attention, either through the form of new medical records, new physical exam findings, new diagnostic study findings, in other words, if there's new facts, new additional facts, then you can decide whether or not your opinion and conclusion is changed or modified based on any of those new facts. But at the time, based upon the facts that you had at your disposal, the opinion and conclusion that you offered is the only naturally right, true, correct, and accurate opinion or conclusion, because only the correct opinion survives the criteria of substantial medical evidence. So I want to encourage you to adopt this way of thinking in every single circumstance in your report where you offer an opinion and conclusion. If you can do this, you will dramatically improve the content and quality and usability of your reports down at the courts where these cases are actually resolved. You know, we as qualified medical evaluators, we don't use our reports. It's other parties that use our reports, and they can only use our reports when our reports reach the lofty ideal of substantial medical evidence. So doctors, I hope this helps you. I want to thank you for your commitment to excellence as a qualified medical evaluator and for your enduring dedication to improving the content and quality of your reports. For now, this is Dr. Perry Carpenter. I'm looking forward to being with you on our very next discussion. And for now, I'm wishing you best success in your career as a qualified medical evaluator.